Well, ladies and gentlemen, first of all, thank you very much for joining us. I had a look at our delegate list earlier, and it was very pleasing to see a real mixture of familiar faces and a number of you who I haven't come across before. I think we have all four corners of Scotland represented, and so far as I can tell, all sorts of interesting practice areas covered, looking at the solicitors and the members that we're seeing on that delegate list. So I'm really grateful to you for joining us, not least because it is, as I was saying privately earlier, it's a lovely day, and the temptation to be out in the garden with an ice cream or perhaps something stronger would be must be great today. I should say that I do find it a bit of a shame that we can't be hosting this event as we have in the past in the High Street in Edinburgh, because one of the things I've really missed about working there is the events that we put on and the social events. And if I'm perfectly honest, I do tend to enjoy having a little bit of a drink afterwards, after these sorts of things. So it's a real shame that we can't be doing that, and I really do look forward to the point where we can meet up, have a glass of something or a cup of coffee, and enjoy these events in that particular way. There is, of course, nothing to stop you from having a drink just now as you're listening into our event, so nobody can see you, and feel free to sort yourself out with a gin and tonic if that's your preference. Anyhow, sorry, it just occurred to me I haven't introduced myself. My name's Andrew Sutherland. I'm one of the clerks and practice managers at Arnot Manderson, and we at Arnot Manderson are going to have the pleasure of being joined in the stable by Kat MacQueen and Sarah Traynor when they call to the bar this Friday. They'll be joining John McPherson, who's on our panel today, and I think probably the best thing for me to do is to pass you on to them just as quickly as possible, because frankly this event, Bit of the Devil You Know, is designed to let you introduce you really to Kat and bring you up to speed with the devils joining us. Before I do, I've just one or two matters of housekeeping. One is to say that we intend with these events and when they're online to try and answer questions that you might have at the end of the talk. So anything that you might have or that might occur to you in the course of the talk, if you would be so kind as to use the Q&A button on your Zoom screen, and we'll try and answer anything that occurs or anything that you would like to question the panel about. If you have any technical difficulties, or if there's something not quite appearing right or what have you, then you should feel free to use the chat function for that type of problem. Yes, there are no fire drills expected. Although I wouldn't put it past my two young children to set something on fire while I'm in the study. But yes, we should all be okay to go just now. And so without further ado, I am going to pass you over to John McPherson, advocate. John.
Good afternoon, everybody. Thank you, Andrew. Can I just echo your sentiments about it being a pity that we can't be conducting this event in person, but I hope we're nearly there with the pandemic, and that it'll soon be in the rear view mirror. I'm particularly pleased to have been asked to introduce Kat to you today. I'm pleased for two reasons. In the first place, I'm delighted because the fact that Kat is giving this talk at all means that she's about to call at the Scottish Bar. I first met Kat in 2018 when she was allocated to note for me in my first High Court trial as a prosecutor. Although at that time she was only in the first year of her Crown Office traineeship, her efficiency and thoughtfulness about the case itself, as well as her interpersonal skills, and some might say considerable compassion in managing the stress levels of a highly anxious first-time advocate depute, stood out. And it occurred to me after the case was over that if Kat chose to do so, she might carve a notable career for herself as an advocate. We kept in sporadic touch, and I was pleased to discover that Kat had decided to come to the bar, and we were put together again earlier this year under a mentoring scheme that faculty runs for Devils. And I was pleased to be able to help her through the process of applying to stables when that time came around. And I should say that I did not at any stage use what might be seen as undue influence to persuade her to come to Arnot Manderson. That happily was all her idea. And that, of course, is the other reason that I'm delighted to be introducing Kat, because the fact that I'm doing so means that she will be one of 2 new members of our stable when she calls on Friday. In offering advice on Kat's stable applications, I became aware and was hugely impressed by her stellar academic background. She took a first-class honours degree at Aberdeen University and followed that up with a Master's in Law from Edinburgh University, which was pursued with the assistance of a UK-EU scholarship and completed with such distinction that she was awarded the T.B. Smith Prize for the most distinguished scholar across all of the LLM programmes offered by Edinburgh. Kat is now about to call, having been a recipient of the Lord Reid Scholarship as one of the most outstanding applicants to the bar. She's going to talk to you today about vulnerable witnesses and special measures. As a family lawyer, this is something that has crossed my desk more and more often recently, and it is becoming a frequent feature in civil proceedings, especially, as I mentioned, in those high conflict cases which deal with contact. It's a highly practical and increasingly relevant topic, which I hope you will find useful. And by the end of Kat's talk, I'm sure that you'll also agree that Arnot Manderson is very lucky indeed to have someone of Kat's caliber joining us as one of its members. So over to you, Kat.
Thank you very much, John. Good afternoon, everyone. I'm absolutely delighted to be calling into the Arnot Manderson stable on Friday, and I'm looking forward to speaking to you today about vulnerable witnesses and special measures. I'll just share my screen, get a PowerPoint. While I was at university, I volunteered with Victim Support Scotland to support witnesses giving evidence in court. I developed a particular academic interest for special measures and vulnerable witnesses, specifically in criminal trials, during the study of my master's in law. And then working as Procurator Fiscal Depute prior to commencing deviling, I was regularly faced with circumstances where special measures were used to assist complainers, witnesses, and also accused persons on occasion in giving their evidence during a trial. I'll be speaking to you today about the use of special measures for vulnerable witnesses in both criminal and civil proceedings. I intend to touch upon some points which practitioners may wish to consider when determining whether a witness is vulnerable, and if so, in assessing which special measures would be the most suitable for that witness. I'll also discuss some circumstances where it may be appropriate to challenge or object to special measures sought by an opposing party. Special measures are a set of arrangements designed to make it easier for a witness to provide their best quality of evidence. By that, I mean that a vulnerable witness is given the opportunity to present their evidence in the most coherent, effective, and accurate manner. A witness can be vulnerable for a wide range of reasons. So, for example, it could be due to their age or a mental or physical incapacity, or it could even be due to distress, which may be suffered in connection with giving evidence. Such vulnerabilities may present as barriers to a witness giving evidence in court proceedings. In recent years, statutory reform has resulted in the increased use of special measures for vulnerable witnesses in both civil and criminal cases. This reform, by and large, arose from one of several government initiatives to aim to treat witnesses in court proceedings with fairness, dignity, and respect. Special measures can have the effect of reducing or removing the stressful environment in which a witness gives their evidence. Some measures actually physically shield a witness from an accused or other parties to proceedings. Such mechanisms can have the effect of relieving the anxiety and pressure which may be felt by a witness, and can also reduce the trauma and psychological harm which may result from giving evidence in the traditional court setting. In criminal trials, the use of special measures acts to safeguard the public interest in securing vital testimony of a witness which may not otherwise be possible, as the witness may not otherwise feel that they can give evidence in proceedings. In relation to both criminal and civil cases, special measures can promote access to justice for parties, as they can assist all parties in placing before the court the best evidence in support of their case. A statutory definition of vulnerable witness in both criminal and civil proceedings was created by the Vulnerable Witnesses Scotland Act 2004. This has subsequently been amended by various statutes, which I've listed on the slide. This PowerPoint will be distributed to you in due course. The definitions of vulnerable witness in criminal and civil proceedings are similar, but they contain slight differences. Turning first to the definition in relation to criminal proceedings. Under section 271 of the Criminal Procedure Scotland Act 1995, there are various different categories of vulnerable witness. First of all, a child under the age of 18 at the commencement of proceedings will be a vulnerable witness for the purposes of the legislation. Another circumstance may be where there's a significant risk that the quality of a witness's evidence will be diminished in terms of completeness, coherence, and accuracy due to either a mental disorder or fear and distress in connection with giving evidence in the proceedings. Being a complainer in particular types of offence, those being sexual offences, human trafficking for prostitution or exploitation, domestic abuse, or stalking, has since 2014 automatically deemed those witnesses as vulnerable. Another category of vulnerable witness is where there is a significant risk of harm to the person, and that's due to the fact that they are giving evidence in the proceedings. In terms of section 271A of the 1995 Act, children and deemed vulnerable witnesses, who are the complainers in the categories which I've listed, are automatically entitled to certain special measures. For other categories of vulnerable witness, there's no automatic entitlement to special measures, and it's therefore for the court to determine whether the witness is vulnerable. In doing so, the court will have regard to various factors, such as the nature and circumstances of the alleged offence, the nature of the evidence which the person is likely to give, the relationship between the witness and accused, if any, the age and maturity of the witness, any behaviour towards the witness by various parties connected with the proceedings, and other relevant factors such as social and cultural background, ethnic origins, sexual orientation, domestic or employment circumstances, religious or political beliefs, or physical disability or impairment. The court must, in considering whether a witness is vulnerable, also have regard to their views and also the best interests of that witness. An accused person can also be a vulnerable witness in criminal proceedings if they meet the definition set out in section 271. If representatives of an accused consider that their client is vulnerable, then they can apply for special measures to be put in place to support the accused while they're giving their evidence, and that's provided for under section 271F of the 1995 Act. The court will consider the same factors as with other potentially vulnerable witnesses listed above in considering whether an accused person is in fact vulnerable. In addition to those factors, they'll also consider whether the accused could be or is legally represented, and also the behaviour of various parties who may be connected to the proceedings towards the accused. If an accused person is a child witness, then they'll be deemed vulnerable and automatically entitled to certain special measures. The definition of vulnerable witness in civil proceedings is set out in section 11 of the Vulnerable Witnesses Scotland Act 2004. Similarly to criminal cases, a witness is vulnerable if they're a child under 18 at the commencement of proceedings, or alternatively, if there's a significant risk that the quality of their evidence will be diminished, either due to mental disorder or fear or distress in connection with giving evidence in the proceedings. You'll see that this definition is broad, as fear or distress resulting from giving evidence could cover a wide range of different scenarios. In civil cases, there are currently no categories of deemed vulnerable adult witness, although there are pending provisions in sections 11A and 11B of the 2004 Act. And when these come into force, they'll create a new category of deemed vulnerable witness in relation to particular children's hearings and parental responsibility hearings involving allegations of certain types of crime. In determining whether a witness is vulnerable, the court will take account of the factors listed in the slide, which you'll see are almost identical to the list of factors in relation to criminal cases. Assessing and identifying a vulnerable witness is not always easy. Sometimes vulnerability may not be obvious and might only become clear as proceedings progress, and in fact, even at the stage where the witness is actually in court giving their evidence. Early identification of vulnerability is, however, crucial in order to ensure that a witness receives the appropriate support that they require throughout proceedings. Practitioners should bear in mind the possibility that a witness they intend to cite may be vulnerable, and this consideration should be continuously monitored and kept under review, as a person's vulnerability may change or manifest at different stages in the proceedings. The Advocate's Gateway is a particularly useful tool for practitioners working with vulnerable witnesses. This is a resource which is viewable online and includes practical evidence-based guidance on vulnerable witnesses and special measures. It sets out the best practice and has been endorsed by the High Court of Justiciary in various practice notes. There are a range of toolkits contained on the Advocates Gateway website, and the various toolkits are tailored to different scenarios. So, for example, there's one including vulnerable witnesses specifically in civil proceedings. One of the toolkits which I've listed on the slide specifically assists with identifying vulnerability. It sets out some practical examples of questions which practitioners may wish to ask a witness and certain behavioural characteristics displayed by a witness which might cause concern and warrant further investigation into possible vulnerability. There are a range of special measures available to vulnerable witnesses in civil proceedings, criminal proceedings, which are set out in section 271 H to N of the Criminal Procedure Scotland Act 1995. I'll cover these first and then do a compare and contrast in relation to civil proceedings. First of all, evidence may be taken by a commissioner. Now, if this special measure is adopted, then a separate hearing will take place in advance of the actual trial itself, where the evidence will be taken from the witness by a commissioner who's usually a High Court judge in High Court proceedings or a sheriff in other proceedings. The evidence will be pre-recorded and subsequently played to the court at the trial. The accused will generally watch the commission taking place from a separate location unless there are special circumstances justifying their presence. Arrangements for the commission will be tailored to the needs of the vulnerable witness, and the nature and extent of the questioning of that witness will be determined in advance of the commission during a ground rules hearing. Parties may be asked to submit written questions for that witness in advance. Full details of this can be found at the High Court Practice Notes, numbers 1 of 2017 and 19. I've referenced these in full at the end of the slides. In relation to CCTV live link, arrangements can be made for witnesses to give evidence during the trial, either from another room within the court building or alternatively from a remote site, while the accused and other parties to proceedings will remain in the actual courtroom. Arrangements can also be made for a vulnerable witness to give evidence by CCTV link, so they will leave the courtroom for the purpose of giving their own evidence. This can be utilised in circumstances where they may find it too intimidating to give evidence in the courtroom itself. A screen may also be utilised. This is a physical screen which is positioned in front of the witness box within the courtroom to hide the accused and members of the public from the sight of the witness. The accused will still be able to see and hear the witness through a television link which is played throughout the courtroom. A supporter is also available to a vulnerable witness. This is usually a person who is volunteering for the witness service in criminal proceedings, which is the organisation I used to volunteer for. Arrangements can, however, be made for an alternative supporter. So, for example, a witness can have someone who's personally known to them if they wish. The supporter may be present whilst the witness is giving evidence and will sit beside the witness box or the location that the witness is giving their evidence, but cannot prompt or influence the witness in any way. So they're simply there as a silent presence. A prior statement may be lodged in place of a witness's evidence in chief, and this will be admissible without the witness having to come into court and adopt the statement. Often, a prior statement will be in the form of a joint investigative interview, which is given by a child or vulnerable witnesses to police at the beginning of an investigation, but it could alternatively be a written statement. There's also a statutory provision for closing the court during a witness's evidence to members of the public other than parties concerned, although certain journalists or people specifically authorised by the court may still be present. There are certain procedural hurdles which must be overcome before special measures can be put in place for a vulnerable witness in criminal proceedings. The full procedure for obtaining special measures for child and deemed vulnerable witnesses is set out in section 271A of the 1995 Act. Child and deemed vulnerable witnesses in criminal proceedings, as I've already mentioned, have automatic entitlement to one or more of the standard special measures. So, in other words, they're automatically entitled to a television live link, a screen, or a supporter, either as a sole special measure or in conjunction with another one. Other measures are considered non-standard and will therefore only be granted at the court's discretion. A vulnerable witness notice or child witness notice should be lodged and intimated in accordance with the requirements set out in section 271A of the 1995 Act. There is a pending provision under section 271AA of the Act, which will soon come into force and bring in a new simplified procedure for cases where only standard special measures are sought by a child or deemed vulnerable witness. And in these circumstances, the clerk of courts will be able to grant such orders administratively without them having to go to a sheriff or judge for consideration. There are additional provisions which have recently been implemented for child witnesses in some of the most serious criminal cases. These categories are set out in sections 271BZB and 271B of the 1995 Act. The presumption is that those particular child witnesses will give their evidence in advance of trial out with the court setting. In those circumstances, the taking of evidence by commissioner with the use of a supporter or the use of a prior statement as their evidence in chief will now be standard special measures, which means that the court must authorise them unless exceptional circumstances justify otherwise. The use of pre-recorded evidence as a standard special measure to which a witness is automatically entitled may well be on the horizon for other vulnerable witnesses, as this approach has been endorsed by both the Lord President and the Lord Justice Clerk. There is a provision within section 271BZD of the 1995 Act, which leaves open the possibility for the provision to be extended in that way. For all other vulnerable witnesses in criminal proceedings, there is no automatic entitlement to special measures. Instead, a vulnerable witness application must be lodged with the court in accordance with the procedure set out in section 271C of the 1995 Act. The court can either grant the application in the absence of parties or will appoint a diet for parties to be heard. In deciding whether it's appropriate to grant an order, the court must consider the possible effect on the witness if they're required to give evidence without special measures, and also whether it's likely that the witness would be better able to give their evidence with the benefits of one or more special measures. Consideration will also be had to the factors which I've set out in relation to section 2712A to F. If you're lodging a vulnerable witness application on behalf of a party, then medical, psychological, or psychiatric reports are influential, but they're not mandatory. It may, however, be useful for practitioners to seek expert advice, particularly if a witness has a series of issues affecting vulnerability. It's important to ensure that the right expert is instructed and that they're appropriately qualified to give an opinion. It may also be particularly useful to obtain a report from someone known to the witness, such as a psychologist or doctor who may be personally treating them. There are, of course, difficulties in securing legal aid funding for these types of reports, but if you can justify why an expert opinion is required, then it will save the court time and money in the long run. In the case of child and deemed vulnerable witnesses, there's no opportunity for the defence to object to standard special measures. So no objection can be made to a screen, television live link, or a supporter. However, if any other special measures are sought, then an objective notice can be lodged in accordance with the procedure set out in section 271A 4A of the 1995 Act. Objection can also be made to any special measures sought by other categories of vulnerable witness through a vulnerable witness application. This objection can be done by lodging an objection notice in accordance with section 271C 4A of the 1995 Act. In terms of section 271D, the court can review special measures at any time, and this includes after a witness has already started giving their evidence. Any party to proceedings can make an application for review, or the court can alternatively review special measures on its own motion. Parties will have the opportunity to be heard, and this provides the defence of an opportunity to challenge the appropriateness of special measures at any stage in proceedings. The court may vary or revoke special measures where the arrangements in place would give rise to a significant risk of prejudice to the fairness of the trial or the interest of justice, which significantly outweighs the risk of prejudice to the witness giving evidence. This provision can also be useful to a party who's cited a vulnerable witness, where it becomes clear that the special measures which have been arranged for them are no longer appropriate. For example, I've had experience where a witness is in the witness box with use of a screen, but is still displaying significant distress while giving their evidence. And so arrangements are made last minute in order for that witness to complete her evidence from a live link in another room instead. There are, of course, several other support measures available for vulnerable witnesses in criminal proceedings. I've provided a few examples on the slide. So a pretrial court familiarisation visit can be arranged by Victim Support Scotland, and this allows a witness to feel more prepared and comfortable with the court environment in advance of giving their evidence. There's also statutory provisions set out in the 1995 Act, which I've listed on the slide, which can prohibit an accused from personally representing themselves in their own trial in certain circumstances involving vulnerable witnesses. Witness anonymity orders are also possible under section 271N of the 1995 Act, and this is available to any witness, not just vulnerable witnesses, but it can be relevant to a vulnerable witness. It can protect the identity of that witness through various steps taken, and in some circumstances, a witness's identity can even be concealed from the accused person. The court also has discretion at common law to regulate proceedings in accordance with fair trial and in the interest of justice. So this affords a degree of flexibility to courts to implement measures tailored to a witness's individual needs. So for example, a judge may decide that it's appropriate during proceedings to come down from the bench and for parties to remove their wigs and gowns, and for proceedings to commence and for evidence to be taken in a round the table discussion, as opposed to from the witness box. Special measures are generally less commonly used in civil cases, but can be just as important in certain circumstances in order to assist vulnerable witnesses in giving their best evidence. I've listed some examples on the slide as to circumstances where the special measures may be particularly appropriate and suitable. So, for example, in reparation claims relating to allegations of criminal conduct, such as rape, domestic abuse, or historic childhood abuse. This is particularly so in relation to historic abuse following the removal of the triennium by the Limitation Childhood Abuse Scotland Act 2017, which has led to an increase in those kind of proceedings. Special measures may also be particularly valuable for witnesses in child and family law proceedings, as these cases can often be inextricably linked to allegations of crime, such as domestic abuse, sexual offences, or child abuse. Often, fatal accident inquiries can involve witnesses having to give evidence of particularly traumatic events involving the death of an individual. However, due to the inquisitorial nature of those proceedings, often a witness's evidence will simply be agreed in the form of a statement where it's uncontroversial, and that means that the witness will not be called to give evidence at all. However, if evidence can't be agreed and a witness does require to be cross-examined, then special measures can assist in that regard. The statutory special measures available in civil proceedings are set out from sections 18 to 22 of the Vulnerable Witnesses Scotland Act 2004. Those are the taking of evidence by commissioner, the use of live television link, use of screens, or a supporter. And as you will see, they're very similar and in fact almost identical to those measures which are available in criminal proceedings, and they function in very much the same way. One difference in civil proceedings is that there's no express provision for the admission of prior statements as evidence in chief. This is because such statements are generally admissible in civil cases anyway, under Section 2 of the Civil Evidence Scotland Act 1998. However, Section 22A of the 2004 Act expressly allows for a prior statement to be used in place of evidence in chief in certain children's hearings proceedings, and that's without witnesses having to adopt their statement. The special measures procedures in relation to civil proceedings are listed on the slide. You'll see that for Court of Session proceedings, the procedure is set out in Chapter 35A of the Court of Session rules, whereas the procedure for Sheriff Court matters can be found in Chapter 45 of the Ordinary Cause rules. In relation to fatal accident inquiries, some procedural guidance is contained within the 2017 Act of Sederant for Fatal Accident Inquiry Rules. Schedule 6 relates specifically to vulnerable witnesses. The procedure for obtaining special measures for child witnesses in civil proceedings is set out in Section 12 of the 2004 Act. A child witness notice must be lodged and intimated in accordance with the requirements set out in Section 12, and the court must authorise the special measures that it deems appropriate for the child. There's a presumption under the legislation that live link or screen, either with or without a supporter, will be appropriate for child witnesses in civil cases. There is, however, currently no statutory presumption in favour of pre-recording a child witness's evidence in civil proceedings, but the use of evidence by a commissioner is being used more and more, particularly in relation to children's hearings. A child witness can only give evidence without special measures in civil proceedings if they express a wish to do so and it's deemed appropriate, or in an alternative scenario, if the use of special measures would result in significant risk of prejudice to the proceedings, to the fairness of the proceedings, or the interests of justice, which significantly outweighs the interests of the child giving evidence. The best interest of the child will always be a paramount consideration, and this was made clear by the court in the case of M against B from 2016, which I've referenced on the slide. In that case, the court refused to dispense with the taking evidence of the child by commissioner. And this was in family law proceedings, and The reason for that was because it was simply not deemed to be within the child's best interests to do so, despite them expressing such a view. There are currently no categories of deemed vulnerable witness in civil proceedings, and therefore no automatic entitlement to special measures. If special measures are sought by an adult vulnerable witness, then a vulnerable witness application must be lodged and intimated in accordance with Section 12. The court will only grant special measures if satisfied that a witness is vulnerable in terms of the Section 11 definition, and if those measures are deemed by the court to be appropriate for the purpose of taking the witness's evidence. In determining whether special measures are appropriate, the court must have regard to the same factors as in relation to criminal proceedings, which I've listed on the slide. You'll see that the court must essentially consider whether the special measures would enable a witness to give their best evidence. The court must also have regard to the views and best interests of the witness. As with criminal proceedings, an application for special measures may be assisted by expert evidence or evidence from persons who know or have treated the witness, such as a doctor or social worker. Expert evidence can be particularly useful if an application has been challenged by an opposing party. In contrast with criminal proceedings, there are no specific provisions for a party to object to special measures in civil cases. However, because the application for special measures is not automatically going to be granted, a hearing may be fixed in order for parties to be heard. Under Section 13 of the 2004 Act, the courts can, at any stage of proceedings, review the position of special measures. They can vary or revoke the arrangements, similarly to in criminal proceedings, if there is a significant risk of prejudice to the fairness of trial or the interests of justice, which significantly outweighs the risk of prejudice to the witness giving evidence. This can be done either on the court's own motion or on application by a party citing the witness, but it's notable that in contrast to criminal proceedings, there's no opportunity in the legislation for an application to be made to review special measures by an opposing party. However, at common law, in the interest of fairness, an opposing party does have the right to at least raise to the court's attention any issues with the appropriateness of special measures. There are other support measures available in civil proceedings, similarly to in criminal cases. There's no specific statutory provision for anonymity of witnesses in civil proceedings more generally, but courts can use its inherent jurisdiction to enforce such measures. And in Scottish Ministers against Sturton and Manderson, the court considered that the provisions in relation to anonymity in criminal cases provide good guidance for civil proceedings where such orders are sought. There is a pending provision in sections 22B to D of the 2004 Act, which will create a presumption that a party will be prohibited from conducting their own defence in specified children's hearings and parental responsibility hearings involving certain criminal allegations. This is not yet in force. There are also no statutory provisions for a closed court in civil proceedings, but of course, many cases involving children, such as children's hearings, will be held in private in any event. The court will otherwise be able to exercise its inherent jurisdiction to close a court in appropriate circumstances where a vulnerable witness giving their evidence may require. Despite the law's presumptions as to which special measures may be appropriate for certain categories of vulnerable witness, each witness will have a unique set of circumstances. One vulnerable witness may receive great benefit from a certain special measure which would simply not assist another in any way. And it's therefore crucial that practitioners properly consider which special measures would suit the best individual needs of a vulnerable witness. Practitioners should always ask themselves which special measures would enable the witness to give their best evidence. An expert report can assist in determining which special measures would be the most appropriate for an individual. Expert advice may be sought from a psychiatrist, psychologist, or an independent social worker, or expert in speech and language difficulties, for example. It very much depends on the nature of a witness's vulnerability. A professional who personally knows or treats the witness may be in a good position to comment on which special measures would best assist the witness. Again, the various toolkits which I mentioned, which you'll find on the Advocates Gateway website, provide particularly helpful guidance as to which measures may be appropriate, depending on varying types of vulnerability. Practitioners should also consider the particular features of various special measures and their specific pros and cons for vulnerable witnesses, which may vary depending on the individual. So, for example, in relation to evidence by a commissioner, the use of this measure has the benefit of evidence being taken in a much more relaxed, informal setting, which can involve an around-the-table discussion in a courtroom or elsewhere, and also the removal of wigs and gowns to create a much more informal environment. The Scottish Courts and Tribunal Service have recently opened a purpose-built suite for the taking of evidence by a commissioner. These suites look nothing like a courtroom and instead have comfortable seating with fixed cameras all around the room to carefully and properly record the evidence. Another benefit of taking evidence by a commissioner is that the evidence is captured at an early stage in proceedings. The closer to an incident that evidence is captured, the better a witness's recollection is likely to be. And of course, testifying in court should never have to be a memory exercise anyway. It also removes from the vulnerable witness the uncertainty of having to wait until they're called to testify in court or during a proof. And as we all know, there are delays which are worse than ever at the moment due to the current circumstances. So this has led to the increased use of evidence by a commissioner in order to be able to capture evidence at an early stage as possible. There are, however, potential disadvantages with the taking of evidence by a commissioner. So, of course, there are inevitable technical difficulties which may arise with pre-recording the evidence. And in some cases, this has actually resulted in a witness having to go back and give their evidence all over again. The commissioner procedure is also quite far removed from the court. So it may lead to a loss of impact of that witness's evidence upon the sheriff, judge, or jury. Although, of course, this is far less an issue for juries at the moment who are viewing proceedings from an Odeon cinema with large screens and surround sound. In relation to the use of a prior statement as evidence in chief, this can have the benefit of a vulnerable witness having to answer as few questions as possible and will generally be taken at an earlier stage in proceedings. However, one disadvantage of this measure is that there may be a lengthy gap between the giving of the prior statement by a witness and then the witness subsequently being called to give cross-examination. The witness may also not have the same opportunity to be warmed up and eased into questioning prior to cross-examination, and then sometimes may have to go almost immediately into cross-examination when they give their oral testimony in relation to that. Practitioners will also want to think about how the best evidence will be presented to the sheriff, judge, or jury. So if a prior statement is, for example, recorded as a joint investigative interview, then that's taken by police officers or social workers as opposed to legal practitioners. And of course, very different styles of advocacy will be adopted. Also, if a written statement is to be used as examination in chief, then this may risk stripping the emotion and rapport achieved from oral testimony. So the impact of a witness's evidence on the court could be lost in these circumstances. In respect of the use of a CCTV live link, this has the benefit for some vulnerable witnesses of removing them from the courtroom setting and providing them with a more relaxed environment to give their evidence. On the other hand, the remoteness of the live link can cause some vulnerable witnesses distress, as it can cause them to feel excluded from the proceedings if they feel that they're the only party sitting in a separate room. There's also a risk that a witness giving evidence in the court building in a different room will still come face to face within the court building, with an accused person or another party in proceedings. As with taking of evidence by a commissioner, there are technical difficulties which can arise as a result of using a live link. And as everyone will know at the moment, from the remote nature of proceedings in this manner, there can be issues with sound quality and the quality of the picture, and a physical and emotional distance can be created between the witness and the rest of the court as a result of that. Although saying that, this does seem to be the way that most trials and proofs have been conducted in the last year. A screen may have the benefit of physically shielding a witness from an accused or other parties to proceedings within the courtroom. It still allows for face-to-face contact between a witness and the lawyers asking the questions within the courtroom, and it may facilitate better interaction and rapport. Some vulnerable witnesses may actually prefer to give their evidence in the courtroom and to be in the same room as the people who are asking the questions. However, even with a screen, a witness may feel unsettled in the courtroom environment and with the knowledge that they're still actually in the presence of the accused or an opposing party, albeit simply being shielded by a screen. It's worth bearing in mind the court's wide powers at common law to regulate proceedings. It's pretty flexible, and it may be possible to arrange for an opposing party to step out of the courtroom during a vulnerable witness's evidence, so that the opposing party is watching proceedings from another room via live link. This would enable the witness to testify in the courtroom itself, and the accused would still, or the opposing party would still be able to see and hear the evidence. A supporter can have the benefit for vulnerable witnesses of them knowing that they have someone sitting beside them and supporting them while giving their evidence, even if that support is only a silent presence. However, some vulnerable witnesses don't like the idea of having a supporter beside them who they don't know, and would much prefer to be supported by someone who they do know personally, such as a family member or a support worker. On the other hand, a witness may prefer not to give evidence with a person known to them listening in, as they may be presenting particularly difficult testimony which they don't want that person to hear. For that same reason, some witnesses would feel more comfortable giving their evidence without any support at all. It's also notable that a person who is due to give evidence in proceedings cannot be a supporter until they've given their own evidence. The most important step in determining the most appropriate special measures is to speak to the witness. Practitioners should carefully and clearly discuss the different available special measures with the witness and make sure that they understand the various features of each before asking for their views on them. It's not necessarily inappropriate to steer a witness in a particular direction, but ultimately it must be the witness's own decision. It's important to go with what a vulnerable witness wants, unless it's not in their best interest to do so. It's also worth bearing in mind that even if a witness is vulnerable in terms of the legislation, they might not want to give evidence with any special measures at all. Some witnesses want to face an accused or an opposing party and effectively want to have their day in court. If this view is presented by a vulnerable witness, then practitioners should take steps to ensure that it is in fact in the witness's best interest to give evidence by the traditional means. Remember though that special measures can be reviewed at any time, and it is important to continuously monitor the appropriateness of special measures as they may change as proceedings progress. We've seen that there are various avenues open to practitioners in both civil and criminal proceedings to oppose or challenge special measures sought by another party. If a witness of an opposing party wishes to give evidence with special measures, should an objection be made? Defence practitioners have in the past raised concerns that an accused or defender may not have the opportunity to properly confront a witness and to challenge their credibility and reliability if they're not giving evidence in the courtroom in the traditional manner. There are also concerns that special measures may suggest that a witness has something to fear, which could lead the fact finder to presume that the accused or defender has done what is alleged. However, current judicial attitude is that special measures afford crucial support to vulnerable witnesses and do enable them in appropriate circumstances to give their best evidence. The courts have confirmed that the use of special measures does not undermine an accused person's right to a fair trial, and more specifically, the right to cross-examination in terms of Article 6.3d of the ECHR, so long as proceedings as a whole are fair. And this also applies to a defending party in relation to civil proceedings. Given the current judicial attitude towards special measures, it's likely that the court will only entertain opposition to special measures in exceptional circumstances. One example of a legitimate opposition may be where the physical size of a witness is crucial to the defence case, and this cannot be adequately assessed through special measures, where the witness isn't in the courtroom giving their evidence in front of the fact finder. A practitioner should think carefully before opposing special measures, as it is unlikely to be in the interest of any party to have a distressed and upset witness during cross-examination. If an opposition to special measures is considered, then it should not be lodged unless there is a properly reasoned objection, which is supported by evidence. It is, however, worth noting that special measures are intentionally not available to everyone. The legal tests and procedural hurdles exist for a reason, and that's to ensure that special measures are only available to those who truly require them. If a practitioner is faced with a vulnerable witness application, they should ask themselves, first of all, is the witness seeking special measures actually vulnerable in terms of the statutory definition? If so, secondly, are the special measures sought by that witness in fact required to enable them to give their best evidence to the court? Any vouching or material that a party has lodged alongside a vulnerable witness application should be carefully checked to see whether or not it does in fact support the application. There may be evidence which contradicts a claim by a witness that their quality of evidence would be diminished through fear or distress in connection with giving evidence. So, for example, if a witness claims to be scared of an opposing party, but in fact there's evidence that the witness has been in regular contact and is in fact intimidating the opposing party. Another example may be where a witness claims to have a medical condition which makes them more susceptible to distress if testifying in a traditional means, but that there's no substantive evidence to support that. Whilst the courts will not entertain frivolous objection or challenge, it is worth raising with the court if you do have a genuine concern that your client's use of special measures will prejudice them, or that the use of special measures will be prejudiced to your client. And finally, I've set out some key resources which are the go-to for practitioners dealing with special measures for vulnerable witnesses. I would again reinforce that the Advocates Gateway is particularly useful, and practitioners should familiarise themselves with the various toolkits available. In relation to criminal proceedings more specifically, the Preliminary Hearings Bench Book contains all of the up-to-date criminal procedure, and it's regularly updated. And the High Court Practice Notes of 2017 and 19 should be given full consideration, particularly in relation to the taking evidence by a commissioner. I'm happy to take any questions, but otherwise that concludes my presentation, and thank you all very much for listening.
Thank you, Kat. It's very difficult with these things, isn't it? Because what I expect at the moment is that there's a virtual round of applause out there somewhere that we just can't sense or respond to. Can I suggest if anyone has any questions, then the chat function is open, but the Q&A function is available to you as well if there's anything that occurs. It occurs to me, I should say that I failed to mention that at the outset that this session is being recorded, and this seminar will be made available via the Arnot Manderson YouTube channel. That's not a sentence I'd ever imagined saying a few years back, but there is such a thing, and the talk today will be up there before too long, and the slides that Kat has produced will be sent out by email. So please feel free to direct your colleagues or your friends to that particular resource as well, if you think that it would be of interest to them. And there may be one or two other talks there that you might find useful, including those from last year. So please feel free to give us a visit on YouTube. I don't immediately see any questions, and I see we're keeping close to 5 o'clock, and I'm also equally aware that it is both a fantastic looking day outside and a football day. So it might just be the case that there are some people who are keen to go off and finalise their arrangements for the football tonight. But yes, nothing seems to be occurring in terms of the question and answers. I suspect that you have done such a comprehensive job in covering that.
Oh, I think there's one question from Zoe.
Oh, yes. So he's asking, if an accused person does not have legal aid, but defence witness requires you to give evidence by commissioner or accused to recover documents from which excerpts are taken by commissioner, e.g. medical records, who will have to pay for the commissioner?
I think that if it gets to the point where evidence by commissioner is required, then I would expect that the Legal Aid Board would be granting funding in order to be able to carry out those various steps, because it would be in the interest of parties. And so I struggle to think of circumstances where that would be an issue, but yeah, I think that legal aid funding should cover that. As I said earlier, this sort of thing can often save the court cost and time in the long run. So if you justify properly in a legal aid application as to why funding should be granted, then it should be granted. And in that circumstance, you would hope that the evidence that you provide in relation to a justification for funding would be sufficient.
I think there may be occasions where a supportive note from counsel for the Legal Aid Board might be produced.
Yeah.
If you're having a real particular difficulty with the board, and let's be honest, that's not uncommon, then perhaps that could be requested from counsel. Yeah,
as I say, in these circumstances, you would hope that the Legal Aid Board would be granting the funding, but you just need to make sure that with the application you're setting out clear reasoning and justification for that funding, and in those circumstances it should be granted.
We have another question here from Alan Robertson, who's asking, do you think giving evidence on commission will become the default position eventually?
Alan, that's interesting. It's actually given rise to a lot of academic debate and discussion, because that is, as you probably know, what the Lord President is trying to push. He wants all evidence to be by way of pre-recorded evidence, which will then subsequently be played at the trial or proceedings. And I think the benefit of that is, of course, that evidence will be captured at an early stage. So that has the benefit of a witness not having to recall their evidence some months down the line, and also in relation to all the other benefits for a witness of not having to go into court and give their evidence. But the difficulty with that is that if the procedure is streamlined to everyone, then there will be cost implications for the Scottish Courts and Tribunal Service, first of all, because giving evidence by a commissioner, it takes a lot of funding and resources in order to actually be able to do it. And given the technological difficulties which inevitably arise in relation to that form of taking evidence, there will be potential problems which arise if they streamline that method of taking evidence to everyone. But saying that, I consider there would be quite significant backlash to the taking of evidence by all witnesses in that way, because ultimately, in most cases where special measures aren't actually required, people would consider that a witness can give their best evidence in a traditional court setting. So if a witness doesn't have vulnerability, then they should be able to go into court and give their evidence. And it's about whether or not the evidence is coherent but also accurate. And in terms of defense practitioners, they would argue that sometimes evidence can only be accurately tested if a witness is actually in the trial or proof, giving evidence in a witness box. So I think the short answer to your question, Alan, is that there is a possibility that in the future, all evidence will be pre-recorded, but I think it's probably unlikely to be the case with all witnesses, especially those who aren't vulnerable, based on the fact that ultimately the traditional court setting is considered to provide the best way of taking evidence, although that is controversial and others may disagree.
Thank you for that, Alan. Anybody else? Any other questions?
I think it might be worth my mentioning for those family petitioners who are tuned in that, of course, the Children's Scotland Act 2020 is extending the categories of proceedings in which vulnerable witness applications will be considered automatic, in particular by the introduction of a new section 11B to the 1995 Children's Scotland Act. The other thing I would say from my own experience, because I have seen, especially in contact cases which are high conflict, an increasing number of applications for vulnerable witness, for special measures, that each case proceeds very much in its own facts and circumstances, and it's very difficult to be prescriptive where there is any latitude about what approach you should take. In one way, the greater the degree to which vulnerable witness applications become automated, the less you have to think about. But when you're confronted with an application and you do have latitude to oppose it, you do have to consider very, very carefully the impression it might create based on the nature of your opposition. And as I say, just take each case as it comes.
Okay. Well, I think that seems to be us in terms of the questions. Again, I suspect that's because everything has been so comprehensively covered, and so thank you both for that. Ladies and gentlemen, once again, many thanks for joining us today. And as has been said earlier, I really do look forward to the point where we can all see each other in person and catch up over a coffee or a drink. In the meantime, thanks to everyone, and we'll see you soon. Thank you so much.
Thank you very much.
Thank you, Kat.
Oh.